go ahead and take it away.
Thank you very much, Stephen. And thank you to all of you who have taken the time to join us here today for Third-Party Risk is Everywhere, Brainstorming Solutions to Supplier Management. One of the things I would like to emphasize at the outset is that we envision this as very much a brainstorming session and would really like to tap into the sort of collective experiences of you all to see, what some potential solutions to this might be. So that said, let me first introduce our panelists. So my name is Josh Harris. I'm the Director of Global Privacy Initiatives at BBB National Programs. And I am very happy to be joined today by CJ Utter, who is the Director and Registered In-House Counsel for Privacy Counsel for Vizio, and Kelly Peterson Miranda, who is Principal at Data Privacy at Amazon. And really what we anticipate doing here today is a roundtable. We're going to have an open discussion about some of the issues around vendor management. We want to look specifically at some of the pain points for the vendors themselves in the process of demonstrating their best practices, but then also the experience of managing the vendors and how it is that you can ensure that you have done your due diligence when you're selecting your suppliers. So with that, let me turn it over to our speakers for a bit of an introduction. CJ, would you mind going first?
Sure. Good morning, everyone, or almost afternoon for all of you on the East Coast. My name is CJ Utter. I work at Vizio. I head up their privacy department, and I'm their privacy counsel there. And I handle pretty much everything from contracts to handling the vendors to, managing risk, everything from A to Z, basically.
All right, thank you very much. And next up, Kelly.
Hi, everyone. My name is Kelly Peterson Miranda, as Josh said, and currently I work for the central privacy team, excuse me, of Amazon, where I'm a principal of data privacy, which means that I work on myriad privacy opportunities, but my chief area of responsibility is compliance initiatives for emerging regulations, where I partner with legal and product and engineering to create privacy solutions focused on preserving customer trust.
Thank you very much, Kelly. So a little bit more table setting for me, and then I would really like to turn it over to our panelists to kind of give their expert analysis of the situation and what we might be able to do to solve it with a little help from all of you. So first and foremost, what is the problem? Well, the problem is for vendors, everybody has a process in place in order to demonstrate that you have the best practices in place and that you are a well-regarded supplier and you can be trusted to perform services for that client. And so for you suppliers and vendors, this obviously means a lot of paperwork and sometimes a lot of redundancy, because a lot of these questions and onboarding processes are substantially similar, given that the contours of the privacy universe hopefully are starting to settle down so that we can see some expected baselines. At the same time, though, for the suppliers, of course, this is for the business partners that are looking for suppliers. This requires them to put together their own in-house process, sometimes designated staff around that. Of course, all of this takes time and effort and energy to manage as well. So what we can see here are, two different friction points for the two parties involved in the process. And what we would like to consider today are what would be some potential solutions around this to resolve some of that friction for both the suppliers and for their potential clients. So, Kelly, because I see you up right now, one of the things that I wonder if you might be able to sort of jump in here is, why do you see this challenge is growing? And just to begin, what are some of the pain points that you have experienced in your role?
Yeah, sure. So, one of the most obvious answers, I think, is our legal obligations are growing, and interoperability between those legal obligations is not always there. For, I think, in-house privacy program managers, especially on similar to me, who are trying to operationalize privacy programs, getting the privacy team for controllers is about oversight. How do you have adequate oversight? What are all the ingress points that third-party relationships are being generated? It's not always procurement, right? Depending upon the size of your business. Engineering is establishing third-party relationships. Marketing teams are establishing third-party relationships. So it's about gaining the right handle on your third-party landscape and knowing then who is responsible for ongoing oversight over those relationships. I think one of the struggles is putting together an effective program to manage the relationship lifecycle. There's a lot of focus at the beginning of making sure that a relationship is papered correctly from a legal standpoint, from due diligence, but then what happens after that? And that's, I think, where some privacy programs start to struggle and start to deal with scalability issues. And so that's one of the challenges that I know personally I have worked on in various roles and responsibilities. But and the challenges are unique, I think, depending upon the size of the organizations as well. You know, small to medium organizations typically comes down to the issue is a resource management. You know, how do you there's not enough people and there may not be budget for a technology based resource to help with that. And for larger organizations, it really comes down to creating something that provides a breadth of oversight that is scalable, that is accurate, that is continuous, and not seen as something that's a point in time compliance activity.
You know, it's interesting you bring that up, because one of the first things that for me that brings to mind is that one of the most obvious remedies to specifically lifecycle management would be if there could be some sort of a universal key, right, to a date. So I guess as you think about Privacy Shield, for example, it isn't on a participant in Privacy Shield to demonstrate to everybody individually where they are at that time. It's that they are currently an active participant and they have an annual recertification cycle. So I wonder if at the top it might be worth considering whether or not such an external sort of annual type life cycle might work to help to put a little bit of structure and order around ideally what we would like to see as an ecosystem, so that broadly people are doing the same things around the same time and they know when it is that they're doing that for. If I'm to understand correctly some of the challenges for the vendors and suppliers themselves, it's that these procurement processes are not keyed to any universal date. They're keyed to the life cycle of the specific engagement. So I think right there would be something that would be worth considering. And I would ask the crowd here collectively to, think about that and think about ways in which you might be able to leverage some of those external metrics in service of that. CJ, your thoughts on the challenges?
I completely agree with Kelly. It seems like we do so much effort up front, so much due diligence up front, and then, as the contract proceeds or as the business relationship proceeds, the due diligence kind of just, takes a back burner, so to speak. At least that's what I find, pretty much across the board. And what I feel is necessary is something that completes that life cycle. So where you're following the vendor from the start, you're getting the questions answered, you're understanding the business relationship, you're understanding the use of the data, what they're doing to protect that data, the sensitivity of that data, clear to the end of the life cycle where you can confirm that they no longer have that data in their possession, that it's been destroyed, or they do have X amount of data in their possession for legal regulations and what is required under whatever applicable law framework that they comply with. So I think that it certainly is lacking. And while we have a lot of tools, various vendors, there's many vendors that are now in this space that deal with the upfront, let's start the process, let's send out the questionnaires, let's gather documentation. We don't really have one that completes the life cycle to the end. So I would definitely agree that there is a shortfall there. And also, I do see a question from the crowd about if you have certain companies and you have subsidiaries across your companies, how do you manage these vendor questionnaires when all the different subsidiaries are doing something? And what I found works best is basically, if possible, a combined privacy department that handles this completely for both your company and your subsidiaries. If that's not possible, there could be some sort of sharing arrangement or sharing agreement where you share these responses or you share the data that's encompassed within the contract or an NDA with this other vendor. You can put the proper language in there to cover that. That's definitely what I would suggest.
And I see,
Yeah, I was going to just jump onto that too, CJ. That's right. Because depending upon how your privacy program is set up, whether you're following a decentralized or a centralized model, I think when you're in a decentralized role where maybe subsidiaries have their own, federated privacy teams, that data sharing between, this hub and spoke approach, I think, is key and essential. And I think it goes back to there should be some sort of collaboration from the formation of the assessment to understand these are the components that, regardless of where we sit within our organization, are tenets of privacy that we're going to be checking for. And then there are different things that can be bolted on that are subsidiary or business units or product specific needs that need further probing. But that takes a lot of upfront work and investment effort. But with a lot of things of privacy, that work that's done upfront is time consuming, but it pays dividends later on.
and this brings to mind, as I'm reacting as you all are sort of making your comments around this, the way in which, for example, the CBPR framework at the front end requires an enterprise to describe the way in which it manages the activities of its subsidiaries, specifically around third-party management. So there's a very specific program requirement that says, what are the ways in which you manage that to ensure that your third parties are bound by your obligations that you undertook at the time of collection. And if you have sort of a decentralized approach to that, that would then be papered and characterized at the beginning of that certification process for you as an enterprise yourself. If you have a centralized approach, that then would also be documented at the beginning of that. So there's a couple of different ways that you might approach that. But as I think about lifecycle management, and I think about the ways in which processes themselves become really important to reducing some of the frictions here, to the extent that you have a management process that puts an expectation on the subsidiaries and that they are done consistently with a globalized approach, they then in turn are in a position to be able to rely, for example, on these external annual certifications as one potential solution. So I'm just trying to think out loud about ways in which we might be able to see, a broad range of approaches to subsidiary management and expectations on that to work to reduce the friction. That goes actually to another question that we have here. I'm not sure, Stephen, if the crowd themselves can see the questions as they come in. But if you cannot, I'll just read it directly. It's from John Howard. It says, I'm curious how many folks do annual or biannual risk assessment reviews for vendor relationships that are ongoing? While we're waiting to get some responses, and if people can see that directly within the chat, please feel free to do so. CJ, what are your thoughts about this, about annual, biannual risk assessments being done in-house? Is this something that you would recommend undertaking? Any challenges you see to that?
Well, there's certainly challenges with bandwidth and, human resource, capital management, how many individuals you have that's willing and able to do this. But on the side, you can also think about, okay, I guess a lot of different things would trigger such a risk assessment if there was a security breach or if the relationship has changed. Typically, a lot of times I see the risk assessment being reviewed whenever there's a new statement of work added or when there's a new engagement letter added, or when there's a new deal that's struck with the same company to do a different relationship or a different product or service. So I do think, that's a good way to review the risk assessments. Now, if it's a very long-standing relationship, you may want to do a biannual one down the road, especially if there's no change and there's not really any sort of notice to review it because, you don't have a new statement of work, you don't have new data going to that company. But typically, the times to review it are when the new contracts come in or when there's a change.
Kelly, any thoughts on this, on the annual, biannual risk assessment approach?
Yeah, sorry. I think there are some factors to consider going into it. What's the risk score that you've assessed, provided to that vendor maybe during that initial assessment? I think the higher the risk, could be based on the data that's being shared, the criticality of that vendor to your service overall. And those are things that may go into necessitating, a biannual risk assessment or or audit of that particular vendor, versus someone who's providing, maybe receiving less data or providing not so critical of a service. You can be relying on other standards or outside assessments maybe to consider. But I think that what's key, if we talk about relationship lifecycle, is if you have a testing and monitoring program in your organization, this kind of third-party ongoing assessment should be a component of that, I believe. And again, based on, whether that's going to be something that team takes on, they engage third parties to help you out with, or you're relying on outside certifications to help kind of bolster that. But I think it all depends on, the question of also going back to what's the risk appetite of your company overall, because that's going to drive, the resources and the timing and the appetite both to take that on internally, as well as, defining the relationship that you have with that third party overall.
Well, going a little off topic here, question for both of you and also for the audience. Thinking about these assessments and what happens in a worst case scenario where somebody fails the assessment or for whatever reason are unable to maintain the standards that you would put out at the beginning, how might we consider the importance of continuity of operations from a business perspective as against maintenance of standards? Because especially in some instances, you might have a supplier or a vendor who is very unique, and that supplier is really the only one that can do it. Any considerations for mitigating against that? I know, kind of parade of horribles. Anything that you could speak to in your experience around that?
Well, I've experienced this firsthand, and basically what I've done is have a discussion with the business unit or the team that's engaging this vendor, discuss the importance of the vendor, discuss the business use case, why they're using this vendor. Are there any viable alternatives? There may be, other players in the marketplace that can provide the same thing that this vendor was going to provide that we may not be aware of, or close to what this vendor was going to provide. So definitely have that communication open with the team to discuss their needs. And then from there, if it's an absolute, we have to have this vendor, then I go a little bit further and then I start the discussions with the vendor, discussing, okay, what's going on? Why can you, for example, not answer this question? Or why do you not have, I don't know, an incident response plan in place? And just really discuss with them what the situation is and what's going on. Sometimes I've been met with a lot of hostility, or I've been met with a lot of, non-transparent answers. Other times they've just been upfront and be like, oh, we're a small shop, we don't engage in that, or we don't get a lot of data from you, for example. That's one of the comments I get a lot. So I really just try to have the discussion with them. And then if we hit a complete stonewall, then, as counsel, I can't tell the company, you have to do X, Y, and Z. I can just counsel my client as to, okay, here's what I faced. Here's the discussions we've had. Here's the information I've received. This is a risk call for the business to make. And I can do the best I can to help you protect the data if this is what you need to proceed with. But, here's the risk, and I lay them out, and here's your alternatives. And that's really, as a counsel, that's really what you need to do for your client. And then they make the decision from there.
Kelly, anything to add on this one?
Yeah, I think this is an important topic. I think that before engaging in any kind of risk assessment or perhaps audit of third parties, there has to be a meeting of the minds between, legal, the business, the business representatives and the privacy team of what is the goal, what are we trying to seek as a part of this, and what happens, like what are the mitigations that we can maybe control and put in place if we receive unsatisfactory answers from a vendor that we are currently working with. And a tough question has to be asked of the business of like, are you willing to walk away? Are you willing to walk away? Can we walk away? And if the answer is no, and we get back an answer that's unsatisfactory, what is within our control, as a controller, from a technology perspective? Are there gating things that we can put up? Can we, are there pseudonymization techniques that can be put in place? Is there data minimization? Like, what can we control to help ensure that our customers are not harmed by the fact that we must engage with this third party in order to provide the service to the end customer at the end of the day, because it all goes back to preserving that trust of the customer that we are providing a service to, by which we have to leverage a third party in order to do that. And so it has to be, if we're checking for these things, are we all aligned that this is what we're checking for? And if we get unsatisfactory answers, are we willing to walk away, knowing that that is a trade-off of doing it? It doesn't get you out of the responsibility of having to, do those assessments. And I think that's also a conversation, because, one solution that, I've been asked is like, well, what if we just don't do this? Like, what if we just don't go ask those questions and kind of, turn a blind eye? Not an option, right? So counsel, providing that kind of, I say counsel, I'm not an attorney, but, providing that advice to the business on the realm of possibilities of what the outcome of that assessment could lead to.
Yeah, that kind of takes the do out of due diligence, I suppose, right? So one of the questions I have for you then is, as you encounter, hopefully these are edge cases, is it that they're pushing you into sort of ad hoc remediations that are sort of outside of the broader process, so that you do have some occasional one-offs where maybe there's some special consideration for this organization or some special accommodation that can true you up to a point where you're satisfied with the due diligence, but it's maybe a little bit outside of what you would otherwise expect of everybody else?
It could be sometimes. And again, it goes back to depending upon the criticality of that vendor. Are you willing to put in place an exception? And if so, how are you going to document that exception? How are you going to have oversight of that exception? Like, it increases your operational burden. So I think having that conversation too with the business of, it sounds nice, in theory, to say, okay, we will do X for this vendor because they provide this or whatnot. But in the long term, you're actually potentially increasing risk, because now you have an exception in an approach. And so who's ultimately going to have the responsibility for that? Most likely that's an exception that can't be overseen by the privacy program. It's got to be overseen by someone, on the business side, whether that sits with product engineering, account management, whomever is the relationship owner. And then how's the privacy team, and the compliance team going to, what's that reporting out and reporting up going to look like to ensure that ultimately this exception doesn't result in a compliance risk overall that ends up being, a problem area for your company and ultimately your customers.
Yeah, introduction of complications into a universe of things that are already complicated is probably suboptimal. CJ, the exceptions universe, your thoughts on it, how to manage it, or do away with it altogether? Sorry to put you on the spot.
I've been faced with those questions as well. Do we have to do this for this vendor, or is it required, or is it necessary? Basically, kind of how I've handled it is like, okay, looking at the sensitivity of the data, we can have certain vendors do certain questionnaires based upon the level of data that they're getting. Other vendors who are getting the whole smorgasbord of data, they have to do a different questionnaire. So, and then if there are any exceptions, definitely that's noted within the contract. There's a lot of guardrails in the contract as far as what they can do with the data, or what is expected of the service provider, or what's expected of this third party. And then that's managed within the contract lifecycle management. And then, within that, you can make notes or tag or, put them up for, review on certain intervals. That's really the best suggestions I have for that.
Okay. All right. This brings me to a slightly off topic, but certainly within the broader scope of our conversation. For both of you, opinions on chasing services. Are these useful? If so, how so? And if not, why not?
On what kind of services?
Chasing services. So third parties that would chase after these organizations to complete, for example, questionnaires that you might send out. But I know that there are a couple of organizations that do those. I don't know if you've had any experience with them and if they're useful to you.
I don't think that they're going to be that effective, just for the fact that usually, if the company's being very resistant on filling out the questionnaire, they usually need a little bit more, what's a nice way of putting this, a little bit more persuasion from somebody within the organization that can really, either move this along or tell the organization, no, this deal is not a good idea. So as far as like chasing them down, I don't foresee that being a very good option. And I think it would just frustrate your purpose.
Yeah, I personally don't have much experience with the chasing service, but I echo what CJ said. Like, no one is probably going to advocate on behalf of your business like someone who is, a part of your business, and also can provide that perspective on why completion of this and why answers to these questions are an important component, and what the compliance team, what the privacy team, what legal is looking for in completion. So while it on paper makes sense, right? It's an extension of your human capital, right? It may free someone up. Does it really? Because you're also then adding another vendor that you have to establish a relationship with. So now are you bifurcating, and almost doubling the work of the people who are ultimately responsible for sending out the surveys and collecting those responses.
Right. In terms of just kind of looking at the policy landscape now, so second international. First, let's turn to the states. You see more and more states are now bringing on privacy laws. You see it with California, Colorado, Virginia, potentially Ohio, and a slew of others. How is this, or is this not, impacting your policies and practices around vendor management?
Oh, it's definitely impacting it because, each one of these laws have their own little key buzzwords or key phrases or key requirements that you have to incorporate within your questionnaire. So for example, let's use California because that's where I'm at as an example. We have CCPA where you say, okay, your service providers, cannot sell your data for any valuable consideration. So one of the questions that you need to think about asking that vendor is, are you planning to sell the data? Are you using this data just for your internal purposes to provide your services? Or would this data have external uses, or would this data be used for anything else, to really ferret down the type of relationship that you have with this vendor? So definitely, as these different laws come out for different states that have different buzzwords or different provisions, those need to be incorporated in a questionnaire so you know, first of all, what kind of vendor this is and where they fall in the legal regulations and the legal scheme, and then also how to manage that relationship with them.
Yeah, absolutely. It certainly has an impact, for those companies that were already dealing with, GDPR obligations, and then you add on US domestic law. It also takes retraining of your internal personnel, because they had a framework. If you had GDPR obligations, you got your employees, your internal employees trained up, and they had a framework with which they were looking at certain issues. Now you add on additional, and so nuances of what does sale mean, what is valuable consideration, like these kind of nuances, and you're asking potentially non-privacy, non-legal personnel to be able to articulate that when they are establishing a relationship potentially with a third party. Because let's be honest, your privacy team and your legal teams are not the ones who are most likely establishing relationships with third parties. They're brought in to help assess those third parties, but those conversations are initially kicked off by people within the business teams. And you have to look at, if you already had an established relationship with a vendor, under a separate privacy regulation, every time new regulations come on, it's a looking through the holistically, what's our relationship under GDPR? Does it change, or are there any nuances under CCPA, CPRA, Virginia, and how Colorado, Canada? I know we're talking about domestic, but still, those things, every time you add something new on, it only creates more necessity for making sure that internally, when we're talking about these things, we're all using a common language. We all understand the common issues that we're trying to find. And that takes a lot of work, which in turn impacts, the speed at which vendors can be onboarded and go through the assessment process.
And so I would assume that it just magnifies the problem when we introduce international on top of that. And so I wonder, just, very briefly, jurisdictions that give you the biggest headache, I guess, not to put any kind of a negative spin on that, but, where are you feeling pain?
The US. I mean,
Definitely
honestly,
the US right now.
you know, when
Tracking all
you're
the
looking,
different laws.
exactly, you know, until we get some sort of preemptive federal law, like this is just going to continue to be, you know, an issue, you know, for companies that may think, oh, we're not located in California, we're not offering services in California, like, whoo, dodged a bullet. Oh, well, here comes Colorado, here comes Virginia. Like, for a lot of places, you know, you see the practicality of like, no, it's the floor, right? We're just gonna have to extend these and think about this and treat, you know, California as the de facto US privacy law until something from the federal government comes out. But yeah, I would say that that is problematic, you know, from a compliance management standpoint, more so than other areas, I think, personally speaking.
Agreed. And then there's also the EU, which, you know, I love the GDPR baseline, you know, that gives you a great baseline to work from and that you know what you expect. But then, you know, in certain practices or certain sectors, you have the local laws on top. So, and sometimes they're not in, you know, a language that you understand. So that's also a challenge. So, you know, there's definitely, you know, different things to work around. And we do have a question that I can easily answer. The question is, do you coordinate with other internal teams such as security or data governance when sending out or developing vendor assessments? And this is absolutely. For example, you know, some of the vendor questionnaires, you know, there's a privacy section. There may be, you know, your compliance with local or regional laws section. There may also be a very large sizely section on information security. So while I review the whole thing and it's ultimately my responsibility to review the answers, I also have other approvers such as IT security, such as, you know, the development teams or the engineer teams or the businesses that you have this vendor to say, okay, you need to just take a quick look at these answers, especially section 2 or section 4, and see how you feel about these answers. So absolutely, it's a cross-platform approach that I take with, you know, making sure that everybody's bought in. And if there is a problematic vendor that, you know, I've discussed it with the teams involved.
Okay. Now, one of the things that, oh, I'm sorry.
I was just going to say, absolutely. I think that anytime, if you have another area of your business that has established a protocol and has a way, it's also, you know, making sure that it's the best way to get the holistic picture, right? Because you can have security without privacy. You can't have privacy without security. So like you need to be walking in partnership with these other components of your business, and the vendor should be answering those questions. But I think a key component of that is accountability. What's your accountability framework internally? Because one thing that I see that's a pitfall is assumptions of roles and responsibilities. Oh, if this is a security function, like security will handle that, privacy will handle that. Who is responsible for vetting these answers? Who is responsible for setting, you know, like the thresholds of minimum requirements or whatever it may be? Make sure that if you are going to take a combined approach, which I think is smart to do, that there is clear understanding of roles and responsibilities of who's going to do what with this information and who's going to own the relationship. Otherwise, it can create a different layer of problems.
Different expectations, different interpretations, which brings me to, you know, one of the things that I think you've both touched on is, you know, different expectations and interpretations coming out, at least across these states, which makes me think that there could be some utility in relying on baselines that could potentially meet the obligations across the different states as a way in which to manage these expectations across your suppliers and vendors. So I'm thinking of, for example, under the APEX system, the cross-border privacy rules, the privacy recognition for processor standards, also Privacy Shield, where you have these external co-regulatory government-backed standards that do have some nexus to the obligations that you see under Virginia, Colorado, potentially Ohio, and to some extent California. These also have this sort of annual certification, third-party dimension to them. They also have the benefit of having a dispute resolution mechanism, which while not a silver bullet for monitoring, is a dimension of monitoring that otherwise wouldn't be there. So one of the things that we've been doing internally is to look at these external co-regulatory frameworks, consider the ways those might be put in service to solve some of these issues. And so I wonder, from a very high level, what your thoughts are, and also the audience, as to using these certifications either as a component of your management process or as your management process altogether. We've certainly internally have done some market research and talked to different organizations. I think that we've seen there's been an appetite for both variations, but I wonder what your thoughts on that is. First to you, Kelly, since you're up on the screen, what do you think?
Yeah, I think it can be both. I think there is value in it. I think anytime you have a third-party validation of something, it provides an extra layer of assurance. I think whether it is the entirety of your management process or whether it's a component depends upon the vendor risk. As I go back to what I said earlier, how critical is that vendor? What's the data sharing that's happening? The higher the risk or the higher the impact, it's probably going to be a component part of your program. If it's a lower risk vendor, then it's probably, as long as they're doing some sort of annual certification, then it can be maybe all that you need to do for that vendor. I think what happens with these frameworks that can be leveraged is it does provide us a commonality of language. Because CJ, I don't know if you find this, I think everyone interprets things slightly differently. And so that is then put into the due diligence questionnaires that they are. And what happens is, without that commonality or standardization of language or even formats of the questionnaires, what happens is things seem to escalate until you have to put humans on the phone with one another from either privacy teams or legal teams. And then there's this, oh my gosh, this isn't going to get done, until you get on a call. And then it kind of de-escalates very quickly because, oh, that's what you meant by that? Okay, I understand. That's not scalable, though. That's not repeatable. And so we have to find a way that we can have a common set of language. And I think that these kind of external certifications that you're talking about are one pathway towards helping reduce that friction and that escalation path that requires interjection of human capital into the process.
Yeah, I mean, I do agree that the certifications, while it's a starting point, I don't think that's the be all to end all. For example, for SOC 2 reports, they're a good starting point to say, okay, I know how the security controls were operating at that organization at that point in time. However, that's not continual. You don't know if 6 months ago, if this was in place, and then now 6 months later, this is not in place. So I think it's a good starting point. It's certainly just a starting point. And I think that would be the same way with other certifications. It's a starting point to open the negotiations, to open the talks as to what is still missing or what is in place. But I don't think it's to be all to end all, especially because not all data is not one size fits all. All of our organizations do something different, and all of our organizations have different uses for the data. So, it would be a good starting point, but it's certainly not a solution that would fit everybody.
What would you think in terms of, and I just wonder about trying to head off at the pass, the potential issue where you have somebody, for example, fall out of compliance who you otherwise need them to stay into compliance with whatever your terms are. Mm-hmm. So at the very beginning of the conversation, you say, you must stay in good standing with X, Y, or Z. This is a term of your engagement with us, I think, is one possibility. And then the other would be, further attestation that, sure, we recognize that at this date, you are in compliance with this, but we would also like your guarantee through some sort of assigning authority that will continue on through the life cycle of our engagement. Are there things and ways in which you might be able to sort of paper these relationships that could help to alleviate future headaches?
Well, you could certainly paper it and say, if you, for example, if you fall below X standards, that you have to remediate it, or, if you have gaps in your SOC 2 report for whatever year it is, that, you have to remediate those gaps or come to some sort of resolution and you have to notify us. I also I'm not going to go into which vendor, but there's also this vendor in the InfoSec world that will, if you subscribe to their service, of course, they will send you notifications saying, vendor so-and-so has fallen below a C on whatever scorecard. And so that automatically will trigger a response within the company to say, hey, let's reach out to this vendor, find out what's going on. Let's look to see if there's been a breach lately, if there's something in the news that we missed, or do we need to do a reassessment?
Yeah.
So there is that service in the InfoSec world. One of I'm sure there's several vendors, but one vendor in particular will do that and notify you.
We have something similar within the privacy certification space, where there are sort of public commitments that are associated with that certification. So to the extent that somebody's fallen out of compliance, then there is a broader public notification, but those of course can then be tailored specifically to folks that might have an interest as to the ongoing compliance posture of that organization. I see Stephen is gracing us with his presence, which can only mean one thing.
Thanks, Josh. And yes, and this concludes our third-party risk is everywhere, brainstorming solutions for supplier management. Thank you, everyone, for joining us. It was a really engaging conversation. Thank you, Josh. Thank you, CJ. Thank you, Kelly. I really enjoyed the session personally, so thank you. We will see you as our audience in our next SPOKES session, Privacy in the Metaverse. Man, that sounds exciting. Starting in about 15 minutes here at 12:30 Eastern or 9:30 Pacific. You can join from your attendee portal page, and we look forward to seeing everyone in that session. Okay, thanks everyone for your time. Have a great rest of your day.